in the matter of Tyne and Wear Passengers Transport Executive and National Union of Rail, Maritime and Transport Workers.
My Lords, in this appeal I appear with my learned friend Madeline Stanley for the trade unions. My learned friends Mr. David Reed QC leads, Mr. Joseph Bryan for Nexus, the respondents. Lords, overnight your Lordships drew to our attention some additional authorities. They should be on your Lordship.
Thank you very much indeed. It remains to be seen whether we want to look at them, but we thought we might.
Indeed.
The other thing I just wanted to say was, I'm sorry if it sounded churlish to insist on you being robed, but I knew from my experience in court yesterday that the air conditioning actually works quite well. You might have found yourself cold if you'd been here.
Indeed.
In the suit. So it was all for your own good. Yes.
It's a great relief to come off the street into this court, I have to say. My Lords, so far as the additional authorities are concerned, our view is that they don't actually take matters much further. I can deal with them at the end of my submissions if your Lordships would wish me to do so, or alternatively I'll deal with them in reply if Mr. Reed thinks that
there was no compulsion to address them, and I think let's see how the argument goes.
Of course.
And then if obviously it becomes necessary for either of you to refer to them, you can, but we've got them. Yep.
Certainly, my Lords. Lords, I was going to deal with some preliminary references in the documents first, then I was going to tell your Lordships the enumeration of the issues raised in the appeal, and then I was going to turn to our skeleton argument, and I was going to follow it really quite closely because, well, for two reasons. One is that Mr. Reed's skeleton follows ours, so your Lordships have got it in the same order, and the second is that it may save your Lordship's handwriting if I do that. So, my Lords, I'm going to take your Lordships, first of all, to an issue which is not an issue,
sorry,
and that is a reference...
One more thing, sorry, I perhaps said earlier. I can see why this was thought to be, it might go over into a second day. May or may not be, but there might be a lot of authorities to look at. We'd be, I think I speak for all three of us, we'd be surprised if it went anything like the full 2 days. But you can no doubt say it all depends how many questions we ask.
Of course.
Yes.
Lords, we understand what your Lordship is saying. So, Lords, I was going to take your Lordship in the bundle of authorities to tab 1, first of all, which is the statutory definition of a collective agreement. I know that my Lord Justice Underhill is only too familiar with these provisions, but it occurred to us that your Lordship's brethren might not be quite so familiar. So this is the Trade Union and Labour Relations Consolidation Act 1992, which is the definition of a collective agreement. It's section 178, subsection 1 of which says, in this act, collective agreement means any agreement or arrangement made by or on behalf of one or more trade unions and one or more employers or employers' associations and relating to one or more of the matters specified below. And collective bargaining means negotiations relating to or connected with one or more of those matters. And then the issues are set out, the first of which, of course, is terms and conditions of employment, within which it is wages and earnings. And your Lordships will cast an eye over the other matters. And then section 179 on the next page records statutorily the important principle in subsection 1 that a collective agreement shall be conclusively presumed not to have been intended by the parties to be a legally enforceable contract unless the agreement is in writing and contains a provision which, however expressed, states that the parties intend that the agreement shall be a legally enforceable contract. So collective agreements in Britain, or at least 99.9% of them, are not legally enforceable. I certainly have come across, indeed litigated one that was legally enforceable between the employer and the union, but that's most unusual. And that means...
one more than I've ever come across. So.
It was the communication workers union in Royal Mail. It was about 5 years ago. Anyway,
okay.
Lord, so that means that collective agreements have legal significance only where they're incorporated into contracts of employment. And that, of course, is the usual situation where there are collective agreements, because it means that the workers are represented by a union or unions, and the byproduct of collective bargaining is that the unions and the employer agree that the substantive terms, at least, if not the procedural terms, but the substantive terms as to what the annual pay rise will be and so on, is incorporated into the employees' contracts of employment, and is enforced by them by enforcing their contracts of employment. Lord, this is trite law, it's not controversial, but I thought that your lordships ought just to be reminded of that at the beginning. Lords, I was next going to turn, by way of introduction to the case, to the chronology. It's a short...
just one question, which I think may come up later, margins, but it might just be useful to confront now. Of course, what you say is trite law. I have at the back of my mind that in some context, I can't remember which, there has been a discussion about whether, when negotiating a collective agreement for the purpose of incorporation, it is appropriate to describe the unions as agents for the individuals into whose contracts, whatever they agree, will be incorporated.
Yes.
My recollection is that courts have fought shy of describing them as agents.
Indeed.
It is simply that they're doing something in the knowledge it will be incorporated, but they are not run as negotiating on behalf of the employees in a technical sense. Is that your understanding?
I think it's slightly more technical than that, in the sense that they're not regarded as the legal agents of the employees who subsequently get the benefit of the contract. But it wouldn't quite be right to say that they're not negotiating on behalf of those workers.
Well, clearly, in one sense they are, but I meant if by on behalf of you mean as legal agents for it.
Yes. Okay. There has been a great deal of academic ink spilt over that issue, but your lordship has encapsulated it. And again, I don't think that the proposition is a controversial one. Just by way of background, one of the problems is, of course, that a union, such as one of the ones in this case, RMT, has in membership perhaps the bulk of the bargaining unit, the constituency on behalf of whom it's negotiating, but not all. So there's a question about those employees who are not union members or not members of that particular union. What is their relationship with the...
Well, that's a real problem with the agency analysis.
Exactly so.
I think actually not an insuperable problem, principle. But anyway, the courts haven't gone down that route. That's the
indeed, they have not.
Yeah.
Thank
you. That I just thought we could get that out there.
And when we will address the issue of privity and the relationship between the union and the employees in due course, but we don't go so far as to say that the union was an agent, but we do say it's a rather analogous situation in a broad sense. So, my lords, I was going to take your lordships next to the chronology, which is in the core bundle at page 76. Just so your lordships can see the overview of the battlefield in a glance. This begins with negotiations 10 years ago, which is hard to believe, which culminated in an offer letter from the employer to the unions of the 10th of October 2012, which the parties and indeed the judge below and the employment tribunal have all called the letter agreement. It was an offer, but it encapsulates, or is said to encapsulate, the terms of the collective agreement. And then there was a dispute which culminated in 2015, the Anderson claimants taking claims to the Employment Tribunal. Then there was a hearing, judgment.
Could I just ask one factual question which I wasn't quite sure about? The Anderson claimants were all members of the RMT.
They were.
That it is, and it's, I think, clear they represent the bulk of the workforce
Yes.
to whom the credit commissioner, but they didn't represent all of them.
Correct.
A, I suspect because there were some non-union members. B, there were some Unite members.
Indeed.
Possibly, though this may not matter, there may have been some RMT members who just didn't want to get involved.
Quite
Yes.
possibly.
Do we happen to know, I mean, there won't be exact figures, no doubt it'll change slightly from time to time, but what proportion of the relevant workforce were represented by the Anderson claimants?
I don't think that emerges in the evidence. We'll check the findings of the Employment Tribunal. I didn't look for it. Probably I should have done.
No, it's just background.
If it's there, we'll find it, my lord. But I should just...
I imagine there'll be no disagreement about the rough. I'm guessing it's a lot more than half, but significantly less than 100%. That may be all that matters.
It could be. There were subsequent claims as well from other groups of workers within the bargaining unit, and I guess that at the end we could certainly say that the vast majority had brought a claim.
While you're just mentioning those, I think there are only four claims which are in the bundle, although at least one of them, I checked them carefully, at least one of them had more than one claimant. But I got the impression it was just a handful of people.
I think the others were just a handful of people.
I wasn't clear whether those were people who had just had second thoughts, or maybe we'll get on the bandwagon after, or whether maybe they were people who had joined since the original litigation. But
I can't tell your lordship the answer.
Mr. Reid is looking expectant. Do you want to tell us, Mr. Reid?
No, well, I'm hoping I can get the information, although I think in fact it's not the bulk of the employees.
Yes,
in
I
the
see.
Anderson
Well,
but
nothing will turn on this, but
Yes.
one just likes to feel firm ground beneath one's feet when telling the story in a judgment. Could I ask you to do whichever research the two you can and give us
Yes.
a broad picture? Doesn't have to. I don't want to spend a lot of time giving precise figures, but a broad picture will be helpful.
we'll get the best we can and see if we can agree it with the union.
Thank you very much. Sorry, do go on, Mr. Hendy.
I'm very grateful. So then your lordships will see that the matter went from the Employment Tribunal to the Employment Appeal Tribunal and thence to the Court of Appeal in June 2018, and my Lord Justice Underhill presided over that Court of Appeal, which he, of course, will remember. And then there was, after the judgment was handed down, your lordship see in January 2019 a letter before action was sent intimating the rectification proceedings, which are the proceedings before the court today, although we're only dealing with preliminary issues.
I'm sorry to ask you, go on asking you questions. In the Anderson litigation, the employment judge didn't actually ever make an order because he didn't want to make an order until the arithmetic had been worked out.
That's right.
It was only arithmetic, wasn't it? His decision meant...
Yes, he found in the applicant's favour on liability and adjourned for a quantum hearing, or I can't remember what it's called in Employment Tribunal.
Remedies hearing, but
effectively.
But well, at least, probably was quantum. Anyway, it doesn't matter, but basically all that was remaining to do was to work out what was owing to each individual claim, which would almost certainly in practice have been agreed.
Yes, absolutely.
But that was that he adjourned, and then that was subsequently stayed pending the appeals.
Yes.
And has remained stayed.
Yes.
In a sense, you might have thought that that would have been resolved in the interval between September 2018 and January 2019, but it wasn't.
No.
So when the rectification proceedings were started, the stay continued. Is that right? So the Anderson proceedings are still on foot.
Yes.
Yep.
Indeed.
Thank you.
So then at the top of the second page, your lordships will see that we made an application for strikeout summary judgment in the rectification claim two issues. One, the preliminary issue of estoppel. We said that the respondents were estopped from bringing the rectification proceedings, and secondly, they should be struck out for abuse of process, and those are the issues that we have to develop before you. And we came before Stuart Isaacs QC, sitting as a Deputy High Court Judge a year ago, and he found against us on those issue, and we sought permission to appeal. He gave us one ground, and we got the other grounds from the Court of Appeal. One ground was not given permission. Lords, I then go from that chronology to the agreed statement of facts, which was agreed between the parties, and your Lordships have that at page 153 of the core bundle. It's relatively short. Your Lordships see from paragraph 1 that it was constructed for the purposes of the trial on the preliminary issues, and over the page it elucidates the status of the letter agreement, which I think your Lordships are all too aware of now. And under the heading letter agreement and individual contracts of employment, the agreed statement says that the Red Book, that was the general collective agreement, and subsequent agreed amendments to it, including the letter agreement, were incorporated into the individual contracts of employment of the employees in grades 1 to 3 in accordance with provisions having that effect in those contracts of employment, and regardless of whether those employees were members of the first or the second defendant or not. And that grades 1 to 3 is the bargaining unit, and the bargaining unit is a term of art found in Schedule A1 of the 1992 Act, which is the process for seeking statutory recognition. Not an issue in this case at all, but bargaining unit has that meaning.
It's a helpful label for the people into whose contracts of employment the relevant terms were incorporated.
Exactly, and on whose behalf the unions are effectively negotiating. In paragraph 14, it says the letter agreement was in the form of an offer put forward by the claimant, which the first and second defendants accepted. Before accepting this offer, the first defendant balloted its relevant members employed by the claimant to ascertain their majority view, as is normal in these sorts of industrial negotiations. Laws, that is a background fact, but I can't claim that it's complete democracy, because all it means is that RMT were balloting their members. It's not as if there was a ballot of the entire bargaining unit.
No, and indeed, so I think for our point of view, it has no legal significance. The legal significance is that the union accepted the offer.
Yes.
And it's only relevant that the union would not in practice have accepted the offer because of its own internal rules if the ballot had rejected it.
Yes. Yeah. And I suppose it casts a very peripheral light on the question of if it were necessary to ascertain the intentions of the employees in relation to the terms of the contract. One could say, well, a majority of them accepted it, but it doesn't shed any light on why they did so, or what the views of those that voted against, or those that didn't vote, or those that had no vote might have said.
What happens in practice when there is a ballot? Is the actual letter agreement sent to members of the union and they're left to read it and make up their own minds about what it says, or is there in fact just a sort of précis of it?
There's a précis of it, and guidance is usually given by the negotiators, and that's what happened in this case. Or almost invariably in these situations, the union will indicate its view as to whether the members should accept the offer or not. Normally the guidance is given by...
It doesn't seem to be suggested in the pleadings anywhere that précis, whatever it said, is of any relevance to issues.
Well, that précis was what, and the recommendation of the union was examined in the Employment Tribunal and the EAT and the Court of Appeal on the last occasion.
It was said to be, though I think I expressed some scepticism as to whether it was relevant to the question of construction.
Yes.
I think the point that was being taken, all this is water under the bridge, but the employer's main point, I think, was that in the letter agreement, the results are the effect of the agreement said to be cost neutral for the employer, and what was meant by that, and that phrase was repeated in the advice in the précis that went to the employees. And I think that's the context in which we looked at the at the advice recommendation to the union members.
Yes.
As I say, I wasn't sure on strict contractual terms it was relevant.
Or indeed what the union meant by...
Or helpful anyway, because nobody could agree what cost
neutrality
meant.
Indeed, indeed.
Thank you.
So just looking on through the agreed statement of facts, not much else I wanted to draw to your lordship's attention, but paragraph 16 points out that the Anderson claimants were all members of RMT and employees in the relevant grades. Claims all time supported and funded by RMT. ET1 claim and attach, we don't need that. Set in 17, they claimed that they'd been subjected to an unauthorised deduction from wages under sections 11 and 13 of the Employment Rights Act. They claimed under a proper construction they'd been underpaid. And Lords, I'm not sure that I need draw your lordship's attention to anything else in the statement of facts, but since it's now been mentioned, I will show your lordships sections 11 to 13. This again is in the bundle of authorities, this time at tab 2. So section 13 says the right not to suffer unauthorised deductions. Subsection 1 reads, an employer shall not make a deduction from wages of a worker employed by him unless A, the deduction is required or authorised to be made by virtue of a statutory provision or a relevant provision of the worker's contract, or B, the worker has previously signified in writing his agreement or consent to the making of the deduction. And subsection 2 says in this section a relevant provision in relation to workers' contract means a provision of the contract comprised in one or more written terms and so on.
Yeah.
And subsection 3 says where the total amount of wages paid on any occasion by an employer to a worker employed by him is less than the total amount of the wages properly payable by him to the worker on that occasion after deductions, the amount of the deficiency shall be treated for the purposes of this part as a deduction made by the employer from the worker's wages on that occasion.
So any underpayment is a deduction?
Indeed, sir. But your lordships will see immediately that the real issue, in most cases, not in every case, is what does the worker's contract have to say? It's a question of contractual entitlement, which is expressed by the statute as wages properly payable by him. So it's what entitlement does the contract give and what entitlement to deduction does the contract make? The only other cases is where statute provides, such as the deduction from wages for the purposes of tax or national insurance. And then the complaints are brought by the mechanism of section 23, complaint to an employment tribunal that there's a deduction in contravention of section 13. I don't think we need more than that. So your lordships will of course immediately see that such complaints for short wages could be brought as a breach of contract claim in the county court or the High Court, but statute has conferred particular jurisdiction on the Employment Tribunal, and the jurisdiction has been enlarged over the years, as your lordships probably know. I forget what the maximum now is in employment tribunals, but it's very significant.
Hang on, sorry. I'm sure you're right, but that's just confused me. I thought, in principle, there's no limit on what you can claim by way of deductions. Is that right?
I'm so sorry. We'll say that again.
There's no limit on what you can claim by way of unauthorised deductions. What there's a limit on is the contractual jurisdiction of the employment tribunal.
Exactly.
Where an employee has been dismissed. Only then. Am I not under? Is this under the extension?
Your lordship may be right. All I was seeking to, and I didn't express it very well, is that in theory, a claim for short wages could be brought as a breach of contract claim in the civil courts, or it could be brought in the employment tribunal. The employment tribunal jurisdiction has been enlarged over the years. It used to be £5,000, and then it was increased, I think, to 30,000. And now your lordship, I think, is right. There is no limit on.
Oh no, sorry, we were at cross purposes. I probably misunderstood what you were saying. Under this Act, what we're looking at, what used to be the Wages Act, which I still sometimes call it, but Part 2 of the Employment Rights Act, there's no limit. You were making the point that you can also claim in the Employment Tribunal for arrears under what is normally called the Extension of Jurisdiction Order, which allows an employment tribunal to determine an ordinary contractual claim for arrears.
Yes.
That, I think, there is still a limit, and I think it is £30,000, but I may be out of date. But I think that only arises in circumstances where the employee has been dismissed. If you want to bring a claim in the currency of your employment in the employment tribunal, the only mechanism available for arrears, the only mechanism available to you is the Wages Act mechanism.
Yes.
Those behind you, or Mr. Reed, will say if I've got that wrong, but unless I...
Those behind me certainly know better than I do what the answer to this is. If Ms. Stanley could help us on
you
this.
and Mr. Reed, you don't need to worry about the details.
My Lord, that's right, with the exception that I think the limit under the extension of jurisdiction order is 25,000, not 30,000.
Okay,
but I agree with your Lordship that under Section 13 there is no limit, and I agree with your Lordship that if somebody remains employed, the only claim is under Section 13.
Right, thank you, we got that clear.
So I'm grateful for that elucidation, but the point that I was very badly trying to make was that this is, at heart, a breach of contract claim.
Yes.
And this is the mechanism that statute has provided for it. If they hadn't provided for that, it could have been done in the civil courts.
Is the Employment Tribunal's jurisdiction to deal with that claim contained in these two sections you've just shown us, or do we find that anywhere else?
I think it's contained in these sections, my lord.
Right. So if we're looking to answer the question, what jurisdiction does the Employment Tribunal have in respect of these claims, we find the answer in these two sections.
Exactly so, and the application, the Anderson application, was brought under these provisions. Lord, the application in the Anderson case...
You may be going to take us to it, but you may not. I speak for myself, I think everything you said is entirely accurate. It's normally a contractual claim. That question was examined by this court in New Century Cleaning and Church. That's where, if you want to see a little bit more discussion of what's meant by properly payable, and also the phrase which about payable under the contract of employment or otherwise, and you mentioned, for example, statutory entitlements, that's the case to go to.
Indeed.
But maybe you're going to go to it later, but if not, I just flag up that that's the source for what you just said.
Indeed, my lord. I was only addressing it for the broader proposition that when one examines what is the cause of action for the purposes of the discussion on cause of action estoppel, at heart, it's a contractual claim.
And just adding one more thing, I see you have in the bundle section 24, so that's the remedy where the complaint succeeds. Exactly
so, my lord. So those 4 sections are the jurisdiction of the employment tribunal to entertain the complaint and to provide a remedy if there is an unlawful deduction.
And just as an obvious footnote, although the tribunal can make an order under section 21A for the payment of the amount of the deduction, if the employer still doesn't pay, you have to go to the county court.
Yes, that's right.
Yep.
Yes, and of course the tribunal can also makes a declaration, which is section 24(1).
Yep.
I was going to take your lordships next to the application to the employment tribunal in the case of Mr. Anderson himself, which is in the supplementary bundle beginning at page 1. I'm so sorry, Lord, I've mislaid my reference here. Would your lordships give me a moment? Yes, I'm grateful. It was just to show your lordships the nature of the claim that was made. It's at page 6. At the bottom of the page, the blank has been filled in by unlawful deduction from wages, and at 7, the claimants seek a declaration, repayment of the unlawful deductions. So that was the nature of the claim in the tribunal. Lord, your lordships have the employment tribunal decision, again in the supplementary bundle, beginning at page 26. There's nothing particular in there I wanted to show your lordships, except at page 32, under the heading of discussion and analysis, Employment Judge Hunter says at paragraph 4.4, it's common ground that the 2012 pay settlement amended the terms and conditions by consolidating the productivity bonus into basic pay and deleting the right of employees to a separate productivity bonus. Prima facie, therefore, the shift allowance is to be calculated by applying the appropriate percentage multiplier to the sum of the previous pay, £200 of the Red Book bonus and productivity bonus, unless either 1, there was an agreement express or implied between the respondent and the RMT that the respondent should exclude form of productivity bonus from the calculation of the shift allowances, or 2, the tribunal should amend the terms and conditions of contract by inserting a clause to that effect. So that was the common ground as to what.
Yes, can we just pause on that too, which I hadn't really focused on before now? Where would the tribunal have the power to amend the terms and conditions? I think I know the answer to this question, but I asked you. How would the tribunal have power to amend the terms and conditions of contract?
Well, I had assumed that he had in mind section 24(1), namely that he would declare what the terms and conditions were by expressing what had, if he had found it, what had been implicit in the words of the agreement. In other words,
well, I'll just tell you what I'm thinking. As I say, this point hasn't occurred to me till this minute, so I may be completely wrong. Was he referring to the jurisdiction under what used to be the contract of the conditions of, or was it called the Contracts of Employment Act, and is now also saying Part 1 of the 1996 Act, where there is a dispute as to what the terms of a contract are, to determine that dispute and say the terms are X rather than Y. It's not a situation in the old days, it was quite a common form of dispute. It's much less common now. There was quite a lot of case law about exactly how far the tribunal could go. It certainly couldn't say what the terms of employment ought to be, but it could say what they were where there was a dispute.
yes,
And this is very unfocused thought, so please don't respond to it straight away. Might that be analogous to a rectification?
yes. On reflection, I think your lordship's right. This wasn't. He couldn't have had in mind the declaration under section 24(1) because that's confined to deductions. He may have. I suppose it was possible to do it that way, but I think your lordship's right and we'll find the section, but he had in mind declaring what the terms of the contract were.
Yes, I'm sorry. Insofar as I've looked at the decisions, it's been very much just focusing on the points that have been brought before us. Well, but everyone can think about that for a bit. It may go nowhere, but when you drew our attention to that, I was a bit puzzled that what's he doing amending the terms of the contract?
Oh yes.
If it's not that, I don't know what it is.
It's a shorthand, clearly.
What's a bit funny is that at 1 he cases for both express and implied agreement, and then in the remainder of the decision he goes on to deal with express terms and implied terms. Look, for example, at 4.7.
Yes.
And then he stops. So whereas in 4.4 he said there's 1 or 2, 2 doesn't seem to lead anywhere.
No, it would have. One would have expected the or to be an and. So
yes.
And in 4.7 he makes or purports to make some findings which might be highly relevant to any question of rectification.
Yes.
Such as that the construction wasn't intended by the respondent and wasn't realised by the claimant.
Yes.
If those were binding findings, they knock out any question of common mistake, I would have thought, or unilateral mistake. But it doesn't seem that's really what he's addressing there.
No. But your lordship's right, and it's a point, obviously, that we make, that the question of mistake is something that could have been determined in these proceedings. Because they could have said, well, the agreement doesn't reflect, as it stands, what the intention of the parties was. It should be interpreted, therefore, in this way.
Wow.
Because
you're making you're stumbling in some very big points in that. I mean,
yes.
And they're points I'm sure you're going to come back to. I mean, that is an important part of the whole analysis, is whether by what route it would have been legitimate for the Employment Tribunal to say the document means this, but it's not what the parties intended.
Yeah.
I mean, you can make observations about that now, but I suspect you're going to come back to them.
Yes. And of course, I'm leaping ahead and making bold assertions that I need to argue much more carefully. But what is relevant to that, and it's the next point I was going to take your lordships to, is that there is a group of claimants called Bolam who brought a claim after the Court of Appeal judgment, so after the terms of the agreement were known. And those claims were resisted by Nexus, and the grounds of resistance are at page 140, begin at 148, and at 155 they set the grounds out in some detail. And at 156, your Lordship see in paragraph 6 that the respondent accepts that the decision of the Court of Appeal in Argaval and our own case, Anderson, is at this level binding authority for the proposition that the tribunal has jurisdiction to resolve an issue as to the meaning of the contract of employment to determine whether a sum claimed under Part 2 is properly payable. If, however, the respondent's application in that case for permission to appeal to the Supreme Court on that issue is allowed and the subsequent substantive appeal upheld, the respondent will contend that the tribunal has no such jurisdiction and accordingly the present complaint should be dismissed. And then they go on.
Out of curiosity, well, it's obvious. The Supreme Court refused permission.
Yes, they refused permission.
Yeah.
Indeed.
Sorry, go on.
I should have said that.
No.
Page 159, under denial of claims, the respondent denies the claimant's complaints on the following grounds. Construction, and then it sets out the same argument again. And then waiver or estoppel, which we don't need for these purposes. But then at the top of 161, mistake. Third, further or alternatively, if on its true construction the agreement provided for the calculation of shift allowance by reference to basic pay as uplifted by both consolidated elements, the agreement reflected a common mistake between the parties and the agreement is therefore void insofar as it's said to operate to increase shift pay in the manner alleged by the claimants. Consequent implication for holiday pay is not occasioned. Fourth, if there was not a common mistake, RMT acting for and behalf of the claimants knew or ought to have known respondent didn't intend the agreement to have effect contended for since it doesn't result in a cost-neutral outcome. Accordingly, agreement is either void ab initio by reason of a unilateral mistake on part of the respondent or alternatively binding only to the extent intended by the respondent or is susceptible to rectification or rescission is unconscionable for the claimants to assert to the contrary. So, I draw your Lordship's attention to this because it's clear that that Nexus considered that mistake was a runnable defence before the Employment Tribunal, one of a number of defences, to a claim for unlawful deductions. So it's difficult, we respectfully say, for Mr. Reid to assert to your Lordships that such a claim not only could not be made, but should not have been made in the initial proceedings. Lords,
just for curiosity, and this is really a point for Mr. Reid to think about, the reference to rectification, or indeed rescission, is made in the context of unilateral mistake. It's not referred to in the context of common mistake, where instead the concept of voidness is the legal label which they attach it to. Moment, I would welcome some analysis, but it needn't be from you,
yes,
about whether voidness is the right approach to common mistake as regards a particular term in a contract. It might be, but I'll need some help on that.
Well, Lords, I hope I don't have to go into that area, but it does seem a very curious relief to seek, namely that the whole collective agreement should be voided so that the workers wouldn't be entitled.
Well, no, but I don't think that's what they're saying. I think it's again, alerting Mr. Reed to the complications
Yes.
rather than making you answer them, said to be void insofar as it's said to operate to increase shift pay. So whether this is the correct legal terminology, it's said to be, as it were, partially void,
Yes.
void to that effect.
Yes.
My immediate thought is that's another way of saying you rectify it to that extent. But
Certainly.
we'll, as you say, not your problem at the moment. You might have to deal with the reply.
No. Laws, but may I say this in relation to those propositions, and I'm going to come to it in a moment, but rectification is the mechanism for addressing or correcting a mistake, whether common or unilateral. But it's dependent, certainly in the circumstances of this case and the case put forward by Nexus, it's dependent on establishing mistake, which would invalidate the agreement as it stands and would require the agreement, as it were, to be rewritten.
So effectively, you're saying whether or not there was a mistake is the substantive vitiating factor, and rectification is simply then a tool for giving effect to
Exactly so.
finding.
Exactly so.
But mistake is used in two different senses, isn't it? One is the mistake about what the parties have agreed when they have agreed something, but they just haven't written it down properly.
Yes.
Which leads to rectification. The other is the argument that because there was a common mistake, there was never a consensus ad idem between them in the first place, and therefore, I think the current position is that any contract is void, or if not void, then voidable. So those are really two different, entirely different concepts.
They are.
Have the same heading of mistake.
That's right, my lord. But the question of whether the remedy is that the contract should be declared to be void or whether the contract should be rectified are matters of remedy and relief, and the consequences of mistake. The underlying issue is whether or not there was a mistake, either mutual or unilateral.
There does seem to me to be a question mark there. I quite follow if, which I think would be very exceptional, you could say that a contract was void, or even if you could say somehow that a particular term was void, then obviously you're within the scope of Section 13 of the Act. If, on the other hand, which encompasses, I think, a wider class of case, you're dealing with circumstances where equity would grant rectification, there's an issue to be addressed as to whether that does fall within Section 13, it seems to me.
Well, except for this, that in the Employment Tribunal, as we've seen in Section 24, there's scope for declaring whether a deduction is authorised or not. And if the tribunal were persuaded of the argument on mistake, they would say, no, they would say, on this hypothesis, these deductions are lawful under this contract.
And then they might say it in two ways, I suppose. They might say, which possibly you don't go so far as to suggest, we actually have power to rectify this contract, so that as rectified, the contract allows the deductions. Or you might say that the tribunal could say, not that it's granting rectification, but that in deciding whether or not the deductions could properly be made, it could have regard to what a civil court would do, and a civil court would grant rectification.
Yes.
Which is a different thing.
Yes, I agree, my lord. But the point I was making was the rather more pragmatic one, that if the tribunal declares that the entitlement under the contract is exactly as Nexus says, because there'd been a mistake, then rectification is completely unnecessary. Why would anybody need to rectify a contract where the employment tribunal had determined that such deductions as had been made by a Nexus were deductions they were entitled to make because of the existence of a mistake? So I accept that formally the tribunal cannot grant the remedy of rectification, but that really is a complete technicality where they can give equivalent relief by way of a declaration that the deductions can be made.
Of course I see the attraction of that, and you may be right, but it's not. If you take a purely commercial law view, I was about to say common law, but of course a lot of this law is equitable, but if you're viewing this outside in the ordinary civil courts, suppose this very claim had been brought in the civil courts, what Nexus should have done, if they always realised that they might need to run a mistake as an alternative, is said in their defence, one, we don't think the contract means this, the written contract means this. Two, if it does mean this, it does not reflect what the parties actually intended. Ignore unilateral mistake at the moment. Counterclaim, rectification of the written contract so as to make it conform to what the parties actually intended.
Absolutely.
Now, you're saying that's just the route that the common law takes, but it's not really necessary. It's as it were an accident of legal history that that's the route it takes. But just suppose you had popped up in the county court and all this argument would be wrong, but there had never been a counterclaim. And said to the court, well, they can't run that because they've never counterclaimed for rectification. I think what you're saying is the county court judge could say, oh, you're quite right, but they don't need to.
Yeah.
But he might say, well, oh no, well, you've always got to claim rectification, but I might give leave to amend belatedly to allow the counterclaim to be introduced. Well, I might not, but for some discretionary reason. But I don't think it's self-evident. I think a strict county court judge might say, no, it's always got to be pleaded as a counterclaim for the remedy of rectification. It isn't, in other words, mistake isn't freestandingly enough for a party to get out of what a written contract says.
No, of course I accept that. There must be some remedy consequent on the establishment that the mistake means that the terms don't reflect the intention of the parties. I accept that, of course. But the tribunal did have the power to make a declaration that Nexus were entitled to make the deductions by reason of mistake.
Well, well, it did. But if, as you were emphasising earlier, ignoring statutory rights, that's always about the interpretation of the contract. They can only make a declaration about what the position is under the contract.
Yes.
If the contract is not rectified, because it's a written agreement, I'm not sure the pointing to the power of declaration really gets over your problem, because the declaration can only be about what the position is under the contract.
Yes, but they are, as they claim in the Bolam response, they are in a position to say to the tribunal, we are entitled not to pay this.
Well,
this
it'd be
money.
interesting to see how Mr. Reid,
Yeah.
no name appears on the pleading, how he deals with it. He may say, we got that wrong.
He may do. But
I mean, suppose that as a matter of law, the the tribunal have got to stick with the contract as it stands unless it is rectified. Why, if it is necessary, therefore, in order to decide whether a deduction is properly made, to decide whether the contract should be rectified, what is there in the statutory provisions you referred to, sections 13 and 23, to say that the tribunal cannot decide whether the contract should be rectified and grant rectification if it's necessary to do so? I mean, you conceded they wouldn't have the power, and we must be grateful for concessions and take them as they stand, I suppose.
Yes.
But I don't at the moment understand why they wouldn't have that power if the law is as my lord was analysing, and it is necessary, therefore, to go into those questions in order to reach a conclusion about a deduction being properly made.
Yes. Well, I think what we say is that the power of the Employment Tribunal is limited to what statute is conferred upon it, and rectification would not appear to be a remedy that is open to the tribunal. But our point is a broader one. In determining what is properly payable, clearly the tribunal are able to consider whether what is written down is the product of a mistake that doesn't properly reflect the intention of the parties. And if they come to that conclusion, they may not be able to rewrite the contract, but they are able to say, under the terms of this contract, Nexus are entitled to make the deductions, and the claimants are not entitled to repayment of that which has been deducted. And the reason for that, we find, is because there has been a common or a unilateral mistake.
I wonder whether deep down there's actually a difference between what you're saying and what both my lords, I think, have been putting to you as a possibility. That although the tribunal may not have a jurisdiction to produce an order for rectification under that name, in order to decide what they do have to decide, they have to look at whether in a civil court rectification would have been granted. Because that is what is implicit in the concept of properly payable.
Yes, and the prior question to whether a civil court would have granted rectification, namely whether the apparent terms of the contract have been invalidated by
that's implicit
of a mistake. Indeed.
Yes. Okay, just make me. Yes, well, that. I mean, my lords may want to pursue that further, but I see how you put it.
Yes.
In the sense that always happens, so getting ahead of submissions you were going to thought you were going to make the next stage, but it's been helpful.
I'm merely introducing us.
Yeah, well, I've never known a case yet where
without making them, but when we come to it, we will find that we've discussed a lot of it, so you don't have to go into such detail. Lords, I was going to take you next by way of preliminary material to the judgment of my Lord Justice Underhill in the Court of Appeal, which is in the supplementary bundle at page 87. I wonder if I could just read paragraph 1, because it's relevant to the determination, which is a question we'll have to come to in a moment. What is an issue and what is a cause of action? My Lord said this.
I'm so sorry. Which paragraph?
Page 87 of the supplementary bundle.
Yes, thank you. Yeah.
Paragraph 1. These two appeals were heard together because they raise an issue about the jurisdiction of the Employment Tribunal to resolve disputes about the construction of a contract of employment in the context of a claim for unauthorised deduction of wages under Part 2 of the Employment Rights Act. I'll refer to this as the jurisdiction issue. Apart from that common point, each appeal raises a distinct issue of its own. In Argyle, there is a question as to whether it's open to the appellant to raise the jurisdiction issue at all because of a concession made in the employment tribunal, the concession issue. For that reason, permission wasn't initially granted, hearing proceeded on a rolled-up basis. In the Tyne and Wear, that's our case, appeal, to which I'll refer to as Nexus, that being the appellant's trading name, is necessary, subject to the outcome of the jurisdiction issue, to determine the substantive question of construction. So, of course, this is meat and drink to every lawyer. You look to see what the case is all about, and then you try and identify what the various issues are within it. I say no more about that than that, but I wanted to take your lordships to page 99, as here my lord is dealing with the construction of the agreement in Nexus, and paragraph 38, as already noted, the issue on which the claim depends concerns how shift allowances should be calculated for Nexus's staff in 3 red book grades, and then sets out how it arises. And at page 101, in paragraph 46, my lord says, much as was said in the employment tribunal decision, it was common ground that that letter constitutes, as a matter of formal contractual analysis, Nexus's offer. And since the offer was in due course accepted, it contains the definitive statement of the agreed terms. I have to return to it later, but it's convenient, and then your lordship deals with other matters. So it's common ground that the letter contains the definitive statement of the agreed terms. And your lordship then at page 103 sets out the discussion and conclusion on the proper construction of the contract. And Mr. Reed advanced some criticisms. As to that, his case remained as below, namely that the claimant's construction of the contract couldn't be right because its effect was that the agreement was self-evidently not cost neutral. Starting point must be the words of what the offer is. And your lordship there dealt with it. I'm not sure I actually need more. Your lordship discussed the point that your lordship touched upon this morning about cost neutrality. And your lordship dealt with various other headings, official at page 106, commercial common sense at page 107, with a quotation from Lord Justice Christopher Clark in Wood and Shaw term. It's not the function of the court to improve the bargain or make it more reasonable by a process of interpretation. Thanks. I've missed the paragraph that I was looking for, and that is in particular under the cost neutrality, paragraph 58. Lord, there my lord says, it is of course not uncommon for one party to a contract to enter into it under a mistake as to what the financial effect of one or more of its provisions is. For example, they may get the arithmetic wrong, or they may, to come closer to what may have happened here, overlook the effect of one provision on the working of a different provision. There are certain limited circumstances in which that mistake may allow them to rescind the contract, but no such argument was advanced before us, and the general rule is that they must take the consequences of their own error, however expensive it may turn out. However, in the present case, the evidence of Nexus's understanding and intention that the effect of consolidation of the productivity would be or appear cost neutral is not extraneous, but it's spelt out in the very document which contains the term of the contract. That makes a difference. The rule that a document must be read as a whole means that it would be wrong to disregard a statement by the offeror in the preamble to an accepted offer letter of what it understands the effect of its offer to be. Such a statement cannot, of course, be determinative, but it must be given weight. So, Lords, the relevance of that is clearly that your Lordship was observing that the argument of mistake had not been advanced in the Court of Appeal, or indeed in the lower tribunals, but your Lordship, although not considering the matter because it wasn't advanced, is clearly not saying that it could not have been advanced, but neither is your Lordship making any determination that it could have been advanced. Of course, I accept.
Well, I was just looking at what my lord said in the jurisdiction part of the judgment at paragraph 18, where he's assessing Delaney and Staples, just because, and then the conclusion at paragraph 27, where it is said that the ET has jurisdiction to resolve any issue necessary to decide whether something is properly payable, and that it would be incoherent to carve out particular kinds of issue which the ET couldn't deal with. Now, all that was said, of course, in the context of construction, and nobody had mentioned rectification, but that reads precisely onto any issue about rectification. And if the true position is that the Employment Tribunal cannot determine a claim for rectification if it is necessary to do so, then what my lord said in those paragraphs would have to be qualified.
Yes. So we haven't put it that high because we've steered away from saying that a tribunal can grant the remedy of rectification. But the effect of it is something that we do adhere to and do advance, namely that the tribunal could have investigated all matters relating to whether or not the wages as paid were, quote, properly payable, unquote. And that includes mistake. And the effect of their judgment, therefore, would be the equivalent, in reality, if not technically, to rectification. And of course, in practical terms, where you've got unions negotiating with an employer, once the issue's determined, or perhaps this case is not a very good example of that, but I was going to suggest that the parties might be sensible and say, well, that's an end of it, we'll act on that basis, but we'll have to see about whether we can recover that in next year's wage negotiations. But as I say, this is a very bad example since the litigation has been going on for 10 years. Lords, I was going to take your lordships next to the letter before action which preceded these rectification proceedings, and that your lordships have at right at the end of the supplementary bundle at page 280. And the point that I'm drawing from it is the elision between the RMT and the employees in the bargaining unit. It's only a forensic point, I do accept, and Mr. Reid quite rightly says, well, this determines nothing. But if your lordships look on page 280 in paragraph 1.1, Nexus, or their solicitors, say, as you know, in 2012, our client, and on behalf of your clients, the RMT entered into negotiations and reached a collective pay agreement against the background of national public sector pay freeze collective agreements embodied in our client's letter dated the 10th of October. Agreement subsequently interpreted by the courts in a manner which our client contends doesn't reflect the parties' common intention leading up to the making of the agreement, or at least doesn't reflect our client's intention. In other words, by mistake, our client's letter doesn't record the true agreement between the parties, our client is therefore entitled to have the agreement rectified on the basis of a common mistake or alternatively a unilateral mistake. So that their elucidation of the issue is that that by mistake the letter doesn't record the true agreement between the parties, a purely contractual issue. And they say then in 2.1 we consider that the appropriate defendants to any claim issued by a client for rectification would be all the employees of our client to whom the 2012 collective agreement applies. But in fact, they didn't issue against all the members of the bargaining unit. They issued against the two unions. So that emphasises the elision between the unions and those on whose behalf the unions negotiated, which is an issue we come to later in relation to privity. And I suppose finally I should pick it up. 5.9, they allege that RMT knew or ought to have known of the mistake. And at 6.1, they say they consider the case is suitable for alternative dispute resolution, in particular direct negotiations between our client and on behalf of your clients, the relevant trade unions. So although they're proposing to bring a claim against the workers, they're proposing to resolve it under ADR by negotiation with the unions. Sorry, I just tracked down one further reference, which was yes, in the core bundle itself, there's a witness statement. There was one from each side, but this was a witness statement by Mr. Bartlett on behalf of Nexus. It begins at page 176. And at page 191, there is the only explanation of how it came about that the rectification proceedings were raised subsequent to the tribunal proceedings. It's at paragraph 61 at the foot of 191. And Mr. Bartlett says, following the conclusion of the Court of Appeal claim and without waiving privilege in the claimant's legal advice, senior counsel raised the possibility of the claimant pursuing claim for rectification against the unions on grounds of common or unilateral mistake. My understanding and that of the claimant's business was that the letter agreement clearly didn't use the words it should have in order to convey the meaning that both sides had agreed it would have. Claimant was advised that rectification was the appropriate remedy in such circumstances and that a claim in the High Court would be necessary in order to obtain rectification unless the defendants agreed to rectification. That was the origin of the rectification claim. So it appears to emerge from advice, possibly from a senior counsel, indeed from Mr. Reed. But it doesn't explain when that advice was given, whether it was appreciated that mistake was a potential defence before the Court of Appeal had given judgment or afterwards. In other words, was it an oversight or was it a calculated deployment of one set of proceedings after the other? That's the only material that there is about the reasoning of Nexus on that point. Lord, then I come to the judgment of Mr. Stuart Isaacs sitting as a deputy. This is in the core bundle at page 80. And if I draw attention now to some passages in it, I hope to avoid having to go back to it in order to make the points as we go through the arguments in our submissions. So, Lords, I begin at page 83. In paragraph 12, where His Lordship says the claimant seeks to have the letter agreement rectified by the insertion immediately after clause 1b of the words, save that it's expressly provided that the consolidation of the productivity bonus shall not operate so as to increase basic salary or pay for the purposes of calculating any shift allowance or other allowance which will continue to be calculated by reference to basic salary or pay, as if the productivity bonus had not been consolidated by this agreement. Now, the effect of those words is exactly the same as the argument that was mounted by Nexus in the case which came before the Employment Tribunal and hence the Court of Appeal. But they reach it by a different route. Here, it's based on a mistake in omitting those words. Claim for rectification is based on an alleged common unilateral mistake as the effect of the consolidation productivity bonus in the basic salary. The financial consequences of the Anderson judgment for the claimant are substantial. Lord, just pausing on that sentence, this is the last but one paragraph, I think it's the last paragraph, under the heading, the agreed facts, which begin at the top of page 82. I wanted to make clear to your lordships that the financial consequences for the claimant being substantial is not one of the agreed facts, which your lordships have already looked at. There's nothing in that about the financial...
well, you're obviously quite right to say that the judge was slightly inaccurate if he gave that impression. But it's pretty obvious, isn't it?
Of course.
I say it in my judgment.
Absolutely. No question. The financial consequences were substantial for Nexus.
Pretty obvious, but you would say irrelevant.
Indeed. But it's slightly more than that. There was no evidence as to what the financial consequences were. It may be presumed that that was the case, but there's no evidence. But equally, the consequences for the employees were substantial. And it seems strange that His Lordship has has taken into account the consequences for one party, but not for the other. Well, I was going to draw attention to, on page 84, in paragraph 20, challenged the outcome of the Anderson proceedings. The Anderson judgment determined, as did the lower tribunals, that the Anderson claimants had a contractual right to shift allowances with a percentage uplift calculated on the basis of their basic salary, including productivity bonus. According to the defendants, the claimant is therefore stopped from disputing that entitlement in the present proceedings. Then there's a discussion of the law, which we can look at again. And at paragraph 28 on page 86, His Lordship says, in my judgment, there's no cause of action estoppel on the basis submitted by the defendants that the claimant is seeking in the present proceedings to challenge the outcome of the Anderson proceedings. I reject the defendant's submission that the claimant is raising in the present proceedings points which were decided in the Anderson proceedings. The Anderson proceedings were concerned with the defendant's members' claims under their individual employment contracts as a matter of construction of those contracts. The rectification claim is not concerned to challenge the Court of Appeal's determination of the proper construction of those contracts. Indeed, it proceeds as it must on the basis that the Court of Appeal's construction is correct, but that the contract should be rectified because of common or unilateral mistake. Now, as it stands, one can't take exception to that, but what Nexus were doing, and which his Lordship appears to overlook, was challenging the contractual entitlement of the employees to that which had been deducted from their wages. And that contractual entitlement had been determined in the Anderson proceedings. Well, next, over the page at 87, his Lordship addresses the question of whether the claimant could or should have argued the arguments that it's now raised by Nexus. And at 29, defendants have submitted claimants precluded by cause of action estoppel from pursuing its rectification claim on the basis that its mistake arguments could, with reasonable diligence, and should in all the circumstances have been argued in the Anderson proceedings. They submitted claimant chose to defend the Anderson proceedings purely as a matter of contractual construction, but it was open to them to have argued that the Anderson claimants had no contractual entitlement on the basis of mistake, a position we still maintain. And at 31, his Lordship rejects the submission. The mistake, if there was one, arose in the context of the negotiation of the collective agreement. Rectification of the Anderson claimant's individual employment contract or the collective agreement was not possible in the Anderson proceedings. It's difficult to see how the issue of mistake, whether common or unilateral, could be satisfactorily resolved, given that the Anderson claimants were not parties to the collective agreement and the defendants were not parties to the Anderson claimants' employment contracts, factors which might come into play in the exercise of the court's discretion whether or not to grant rectification would not have been relevant in the Anderson proceedings. Now, we challenge that, but I'll come to that later. And then he goes on, for those reasons, notwithstanding the claimant's grounds of resistance in the Boland proceedings, that's a reference to the pleading of mistake, I don't consider that it was possible, with reasonable diligence, for the claimant to have raised the mistake arguments in the Anderson proceedings. Even if it had been possible, in my judgment, those arguments were not ones which in all the circumstances the claimant should have raised. This outcome also works justice, since, in my judgment, it would not be just to deprive the claimant of the opportunity to advance the rectification claim against the defendants, whatever may be the claim's merits, on the basis of the outcome of the Anderson proceedings. Were the claimant stopped from pursuing a well-founded claim for rectification, it would mean that the outcome of the Anderson proceedings would have significant financial consequences in respect of every employee of the claimant in whose employment contract the letter agreement was incorporated. So the first finding there is that it wasn't possible with reasonable diligence for the claimant to have raised the mistake arguments, and secondly, a reliance on injustice to Nexus because there would be significant financial consequences to it in respect of every employee. And once again, we see no reference to the significant financial consequences of every employee, every relevant employee. His Lordship turned to issue estoppel at the top of page 88 and concluded in paragraph 35, for the reasons stated above in the context of cause of action estoppel, the claimant is not issue is stopped from pursuing the rectification claim here. Mistake issue was not necessarily common to the Anderson proceedings and the present proceedings, nor could it with reasonable diligence, or should it in all the circumstances, have been raised in the Anderson proceedings. In view of the significant financial consequences referred to above, I would, had it been necessary to do so, therefore have held that the special circumstances exist in which it would not be just to deprive the claimant of the opportunity to advance the rectification claim against the defendants.
It's not clear to me what he was thinking the outcome of that would be. He's thinking of the consequences of employees other than the Anderson employees. Let's just assume, for the sake of argument, the Anderson employees were half the relevant workforce. He's effectively saying that rectification of the agreement should be allowed to proceed. Well, would the consequence of that be that the Anderson claimants would lose out as well if it succeeded? Or was he saying that must be, I think, the consequence, mustn't it? Not just the ones who had not yet brought proceedings.
Oh, absolutely. Everybody would lose.
I think that must be it. But it's a bit of a puzzle then why he's making a distinction between the two groups. I mean, the financial consequences are large enough if you look even at the Anderson ones. I mean, maybe I'm wrong. Maybe the Anderson employees are actually only a small proportion.
No, I think they're a significant proportion, but if you're going to rectify the collective agreement...
No, well, I think that must have been... I mean, there's all sorts of questions about that.
Yes.
But that must be his thinking.
Yes.
But in that case, I'm just not quite sure why it matters that there are other employees who haven't yet brought claims.
No, absolutely. I mean, he spells it out at the foot of 87. Financial consequences in respect of every employee of the claimant in whose employment contract the letter agreement...
Yes, but I think the point he's making is even employees who hadn't brought the Anderson proceedings. I think that's the thrust of it.
Yes.
But I can't... Anyway, don't worry, I'm just thinking aloud, and again, I think it's a point in your favour, so Mr. Reed can deal with it. I still think
I'd best not disturb it then, my Lord. My Lord, I just draw attention to that phrase in paragraph 35, special circumstances, because that's a term of art in relation to issue estoppel, and the meaning of, or there's an exclusion, as it were, from the effect of issue estoppel where special circumstances exist, and I'll come to the jurisprudence on that in due course. But one thing appears not to be the case, and that is that special circumstances have ever been held to apply simply because one party to a contract might suffer substantial loss. He then deals with privity of interest, reviews the cases, and in paragraph 41 he comes towards his conclusions on that point. He says, after citing Gleeson, in the present case, I'm satisfied that the defendant's interest goes beyond mere curiosity or concern. The question as put in Gleeson is whether, having due regard to the subject matter of the dispute, there's a sufficient degree of identification between the Anderson claimants and the defendants in these proceedings to make it just to hold that the Anderson judgment should be binding on the claimant in the present proceedings. He cites Lord Justice Floyd in resolution. We'll come to that judgment in due course. He says at 43, adopting the approach taken by Lord Justice Floyd, I accept that the defendants had an interest in the subject matter of the Anderson proceedings. However, I don't accept that the defendants can be said to be in reality the party to the Anderson proceedings. The facts that the Anderson claimants were members of the RMT, that their claim was being supported and funded by the RMT, and that the letter agreement was in issue in the Anderson proceedings and is in issue in the present proceedings are, in my judgment, insufficient for that purpose. RMT couldn't have been a party to the Anderson proceedings, couldn't have brought the claim which the Anderson claimants brought. Whether or not the defendants could be said in reality the party to the Anderson proceedings, I don't consider that it would be just that the claimant should be bound by the outcome of the Anderson proceedings for the reasons already stated. My judgment, fact relied on by the defendants, that from a practical viewpoint, the construction of the letter agreement arrived at in Anderson would affect the collective negotiations going forward, is a factor in favour of the claimant and not that of the defendants in determining whether it would be just that the claimant should be estopped from pursuing the rectification claim. I'm not sure I really grasp the meaning of the last sentence, or indeed, if it's relevant, why that doesn't affect the employees in the bargaining unit. But I really draw attention to note the way in which the judge came to the conclusion that there was no privity between the unions and the employees, and it's on the basis that they weren't in reality the same party to the previous proceedings, which we say is simply the wrong approach to the question.
I mean, I suppose this arises in a sense because there's been a change of heart from the letter before action, because the letter before action proceeded on the basis that the defendants to the rectification claim would have to be all the employees. And that would obviously have included all the Anderson claimants.
Yes.
And then they would have been able to say, well, we don't need to worry about privity. So this reflects the fact that the defendants no longer include any employees. They include simply the unions.
Indeed. And that change of heart enabled them to raise that argument that there was a distinction between the unions and the employees. But we say it's the wrong test. The question is whether there's sufficient identity.
Yeah, so I think, perhaps I'm saying the same thing. That clear, of course, they weren't parties. The judge wasn't saying that was, but he's. But I think it might well be argued that in reality, there's obviously a distinction between being parties technically and being parties in reality. That's the test the judge is applying. But even, you say it's the wrong test, but even if it was the right test, quite a strong argument, they are parties in reality. They are, as it were, funding the agreement, funding the proceedings, bringing the proceedings for their members.
Absolutely.
Which is what unions do.
And indeed, the evidence given in the prior proceedings was on behalf of the unions. Who else could say this is what the agreement properly construed meant?
Well, the assumption of the present proceedings is that if Nexus can get an order for rectification against the unions, that will automatically be binding on the members, well, indeed the employees, even those who are not members. So that's obviously what Nexus think.
Yes.
And it seems to be what your side thinks as well, because if that were not the case, you wouldn't have any interest in defending the proceedings.
Absolutely.
So that in itself might be thought to indicate quite a strong identification between the unions and the employees.
Indeed. And the technical word that's used in the case is privy or privity rather than identity, which in our submission is a better term.
I have to say,
Privity.
Word, I slightly wonder whether the revised assumption is correct, that it's good enough to have the unions as defendants. I do wonder whether myself, if you want to get rectification of a collective agreement that's going to bite on all the employees, you actually do need to join all the employees.
Well,
I mean, that doesn't worry you for this purpose. That would be a basis for saying that Nexus could not proceed with its rectification claim without joining the employees.
yes. Lord, with respect, we think that's a formidable argument, because the proposition we started with this morning is that a collective agreement is not enforceable, it's not a contract. The contracts are between the employees and the employer. And that's what their Nexus is seeking to rectify.
And you would have thought that each employee has an obvious interest in this question.
Absolutely. Yes, 10 years of back pay must be quite significant, I would think. So, Lord, reading on, in paragraph 44, I can pick it up in the last sentence. Question in the present case is whether it's just that a party to the previous litigation, the claimant, should be bound by the outcome of that litigation as against the new party. I don't regard those differences as material to the outcome of the privity issue in the present case, and the contrary was not suggested by the parties. Then his lordship deals with our application for strikeout on the grounds of abuse, beginning at paragraph 47, reviews the authorities, and at 52 says the defendant submitted that the rectification claim is an abusive process on the ground that it amounts to a collateral attack on the Anderson judgment. According to the defendants whose detailed written submissions are set out, the claimant is seeking to relitigate the Anderson claimant's entitlement to shift allowances as determined by the Court of Appeal. If the rectification claim was successful, the result would be inconsistent with the Anderson judgment. It was an abuse for the claimant to have failed to raise the mistake issue in the Anderson proceedings and to apply for a stay of the Anderson proceedings in order to pursue the rectification claim. Wouldn't be in the public interest to duplicate. I reject the defendant's submissions. The fact that the Anderson claimants and the defendants are different is a powerful factor in the application of the broad merits-based judgment. I don't accept that the claimant is seeking to relitigate the Anderson claimant's entitlement to shift allowances as determined by the Court of Appeal in the Anderson judgment. The rectification claim was not and could not have been made in the Anderson proceedings. I also don't accept that if the rectification claim were successful, the result would be inconsistent with the Anderson judgment. Anderson judgment concerned with the proper construction of the letter agreement. Rectification claim is concerned with whether the letter agreement, on its proper construction, was the result of a common or unilateral mistake such that it should be rectified. It doesn't involve a relitigation of the construction of the letter agreement, nor does it, and does not constitute a collateral attack on the Anderson judgment. My judgment, the defendants also can't rely on the claimant's alleged failure to raise the mistake issue in Anderson or to apply for a stay in order to pursue the rectification.
Yeah, unless, sorry, Mr. Lord Hendy, up to now you helped, but you don't just need to read great chunks of this out.
I'm so sorry.
Well, just draw attention to points which you
I'm so sorry. I should have done. In paragraph 53, I was drawing attention in particular to the way it was put, the entitlement to shift allowances, not seeking to relitigate that, but in fact that's exactly what Mr. Reid is trying to do. And in 54, just picking up the second sentence, I accept the claimant's submission that its decision to exhaust the issue of contractual construction before issuing rectification claim was commercially reasonable and proper. It may well be that the possibility of rectification claim only became apparent following Anderson, in which case the claimant's conduct not taking the steps referred to was not the product of any deliberate decision to defer making the rectification claim. Whether or not that is so, I consider the claimant's conduct was not in any way culpable or improper, and that doesn't render the rectification claim an abusive process. Now, Lord, if Nexus hadn't been advised of the possibility of a mistake claim, one might have thought that that was culpable or improper in their failure to advance the claim in the employment tribunal. Finally, Lord, they deal with rectification in 56. We submitted that the letter agreement is a collective agreement which is not legally binding or enforceable, and as such the court has no power to rectify it. And in 57, we drew attention to various points that the unions are not bound by the letter agreement, claimant's employees are bound by its terms through their individual contracts. 3, next to impossible to determine the subjective intention of the parties. 4, if the wording was capable of being rectified, the appropriate defendants to the rectification claim of the employees into whose employment contracts the collective agreement was incorporated, as my Lord drew attention a moment ago. And he says, in my judgment, rectification isn't confined to legally binding contracts, and states authority, and in paragraph 60, Canadian authority, which I won't read, but bar the last sentence, the position in Canada with regard to enforceability of a collective agreement appears to differ from that in England, Toastmaster case. However, that doesn't affect the conclusion that rectification is not confined to legally binding contracts. It's a point I'll make shortly in due course. And 62, as to it being allegedly next to impossible to determine the subjective intention of the parties entering the letter agreement, maybe the difficult questions will arise as to how the claimant can prove the mistake relied on, and in particular as to the persons whose intentions are relevant for that purpose. That difficulty doesn't appear to have prevented the Canadian courts from rectifying a collective agreement. I should perhaps just say there, my Lord, that Canadian law and US law is completely different. Collective agreements there are made between unions and employers and are legally binding as between them. So the intention of the employees on behalf of whom they are made is a complete irrelevance. And it's not surprising that in Canada collective agreements can be rectified for that reason. Finally, he deals with Larche's acquiescence and delay, which is a point which is not pursued on the appeal and for which we didn't get permission. So, Lord, that was all the introductory material. I don't know if it would be helpful, but I just set out in a list the issues which are raised on this appeal, just in a few words. Number 1 is cause of action estoppel. Number 2 is issue estoppel. And then in relation to both of those, there is A, whether there was a challenge to the Anderson decision. B, whether mistake could and should have been raised in the tribunal proceedings. And C, whether there is sufficient privity between the unions and the employees. And D, in relation only to issue estoppel, whether there were special circumstances precluding the unions from relying on issue estoppel. Going back to the main list, the third ground of appeal is abuse of process. And fourthly, whether a collective agreement may be rectified. Lord, on that basis, I hope now that I've significantly shortened my submissions. I was going to take your lordships next to the written submissions and use it as an aid memoir. just highlighting some passages, and I can take your lordship to page 5, page 4, page 28 of the core bundle. Your lordships have it there. And we set out the material propositions of the Employment Rights Act, and in paragraph 16 we mention the case that my Lord Justice Underhill referred me to, New Century Cleaning and Church. Sum is probably payable if it's payable pursuant to a legal obligation. Such a legal obligation will commonly, although not invariably, arise out of a contract of employment. And we say that the material question for the tribunal was whether shift allowances calculated by reference to basic pay incorporating productivity bonus were properly payable for the purposes of section 13. And we say that because they constituted, we say, a contractual entitlement. So the tribunal was obliged to make a declaration to that effect and order payment of the deductions which had been made. And on that basis, we say that the claim turns on establishing a contractual right to the elements which have in the letter agreement. At the end of 18, we say that was the issue before the tribunal. We say that was the cause of action, indeed, before the employment tribunal.
Do you mean the contractual entitlement or the properly payable?
Either way, we say that they are effectively saying the same thing.
Well, the cause of action or the claim was that there had been an unauthorised deduction. In order to resolve that question, the contract needed to be construed.
But for the purposes of cause of action, estoppel is not the technical basis on which the claim is brought. It's what is the underlying cause of action? What is the basis for the claim that's going to be made?
Wow. These are slightly slippery terms. I thought formally, my lord must be right. The cause of action is the making of an unlawful deduction. You're entitled to say that means the non-payment of a sum which is contractually due.
Yes.
It is therefore certainly a necessary, non-payment of a sum which is properly payable. And in this context, that means properly payable under the contract of employment.
Yes.
That issue, therefore, has to be determined. Whether you call it the cause of action or not,
well,
it may be debatable, but I'm not sure when we come to the case law that these fine distinctions are actually necessary. But you're going to take us to Zodiac.
I am going to take you to them, but I should say at the outset, so far as I and my learned junior could see, there is nowhere actually defines what a cause of action is for the purposes of a cause of action estoppel.
Well, that's because it's a flexible term. I mean, cause of action is a statutory term. Then you'd have to see what it meant.
Yes.
But
we shall certainly say to your lordships that
I think there are plenty of definitions of cause of action.
Yes.
Especially in the days when people paid a lot of attention to proper pleading.
Yes. And I remember.
I can actually remember one which simply, I can't remember who it is, probably my lords remember. Somebody says it's that combination of pleaded facts and legal principle which gives rise to an entitlement to relief. It's not that's a paraphrase, but it is it's something like that. I'm sure if somebody went and had a look in Stroud, they would find several definitions of cause of action.
Yes.
You get it a lot in limitation.
Yes, you do.
Yes.
think the classic statement my lord is referring to was Lord Justice Diplock sometime in the mid-60s.
In Tode, perhaps. Yeah. Anyway, I think whether it ultimately matters, I don't think you're right to say there's no definition of cause of action, but exactly what it means may depend on the context in which the concept is being deployed.
Exactly, my lord. I wasn't suggesting that there's no definition of cause of action. I was suggesting that I couldn't find one in relation to cause of action. Estoppel. But as your lordship says, it can't be that it's a purely technical description of the route by which rights are enforced.
Well, I think the sooner we get to, which I think we do in your skeleton, the sooner we get to Zodiac, the better. Right?
Indeed. Indeed. Well, Lord, just before I leave that question that your lordship put to me, we do say if we're wrong about cause of action being here contractual entitlement or what is properly payable, then we say certainly that was an issue in whatever the cause of action was, and that was determined.
It doesn't matter to you, ultimately, whether it's analysed as cause of action, estoppel, issue estoppel, or indeed abuse of process, except that for issue estoppel, there's a little bit more flexibility.
Yes.
In circumstances. Abuse of process, there's a little bit more flexibility still because you take a sort of holistic view.
Exactly so.
But really, it's all the same sorts of factors.
It is.
It's just the test is a bit higher, or the test is a bit more rigorous as you go up the chain.
That's absolutely right, Lord. And there's a very neat summary of it in a case which I'll bring your lordships to in just a moment. So, my lord, coming then to the preliminary issue at page 30 of the skeleton, which is the cause of action, estoppel, we do turn to the Zodiac case, Virgin Airways and Zodiac. That's tab 28 in your lordship's volume of authorities. And it's Lord Sumption's judgment. The facts in that case are quite complex, but I'm not sure that it's necessary to deal with them in any degree. But the passages are quite extensive. I wonder if I could invite your lordships perhaps to read them to yourself. It begins at page 180 of the law report at paragraph 17. And either we or my learned friend have marked it through to page 186.
Do we need to read all of it, or at least you can break it up for us?
Yes, certainly I can.
But I certainly think it's important that we read 17 again to ourselves.
Lord, I'm very happy to perhaps just draw attention to some passages, but I don't want to interfere with your lordship's private reading.
This is what I'm going to propose. That first of all, we just read 17, which is quite long, but really, I think, creates the taxonomy for everything that follows.
Indeed it does.
And then we can see where we go from there.
Certainly.
Okay. Speaking for myself, I've read 17, and just looking ahead, is there a section where he peculiarly discusses cause of action estoppel? Where it comes up at various different points. I mean, para 18, which is Henderson and Henderson.
Yes.
He says aspects of it can be said to be cause of action estoppel, but I'm in your hands, and my lords must speak up if they want to be. I think for us just to sit here and read right up to paragraph 26 is not a useful use of time.
Certainly. Well, look.
Yeah.
Do you really get anything useful again until paragraph 22, by which time there's been discussion of Arnold?
Yes. Well, let me have a go, my lord, and you can stop me if you think I'm not being helpful. Can I just say in relation to paragraph 17, there are 6 principles identified in that paragraph.
Yes, or arguably 5 and an underlying principle.
Yes. However, in his enumeration of them, the first principle is cause of action estoppel. Yep. The second and third don't appear to us to be relevant to this case. So they can be conveniently ignored, unless Mr. Reed thinks they're relevant. The fourth principle is issue estoppel. That's at letter F. And the fifth principle is at G, the Henderson and Henderson principle. And the sixth is a couple of lines below that, abuse.
Yes. Yeah. Well, I'm speaking for myself and subject to Mr. Reed. I agree with you. We're basically looking at 1, 2, and 4.
Yes. So,
sorry, 1. Well, I'll start again. So, sorry, we're looking at 1, 4, and 5. Yeah.
Yes. So, my lords, his lordship deals in 18 with the Henderson and Henderson judgment and Vice Chancellor Wigram. The quotation is a well-known and famous one, and your lordships probably have that in mind. But on page 181 between B and F, very familiar.
My lords, and say we don't need to be taken to that, unless there's a particular point you want to get out of it.
No. So in 19 he says that's the commonest form of res judicata. And at, I just pick it up at letter H on that page. Lordships agree with the view expressed by Mr. Justice McMullen that the true doctrine in its narrower sense cannot be discerned in the present series of actions, and so on. But there is a wider sense in which the doctrine may be appealed to so that it becomes an abuse of process to raise in subsequent proceedings matters which could and therefore should have been litigated in earlier
But all this is really just important and helpful legal history, tidying up
Indeed.
Where we have now got to, which is already summarised in paragraph 17. I'm inclined to agree with my lord, unless you particularly want to rely on something. Can't we really go to 22, which summarises the effect of Arnold, which was the last word of the House of Lords before Virgin.
Indeed. And the essence of Arnold is set out at page 182 in the indented.
Let's just read paragraph 22 to ourselves again. I mean, 22.2 is important.
Yes.
Because if what I put to you earlier, adopting an observation of my lords, is right, that actually the cause of action in the employment in the Arnold, in the Anderson proceedings was unlawful deduction, you say, well, perhaps, but that whether there was a contractual right, or rather more accurately, whether or not a sum was properly payable pursuant to the contract of employment, was a point essential to the non-existence or non-existence of that cause of action.
Exactly so, my lord, yes.
And that included whether it was vitiatable by mistake, whether what would otherwise be such a right was vitiatable by mistake. And that too would be a point not raised in the earlier proceeding.
Exactly.
That's how you put it.
That's how we would put it on the judgment.
So 2 is important, and then 3 is more about issue estoppel.
3 is the special circumstances exception.
Yeah. Well, again, speaking for myself, although 23 and 24 are important points of legal history and analysis,
Well, the
are
only
they
thing,
actually helpful to what we have to decide now? It's true, we will have to, when we get to the Henderson, we will have to look at Johnson and Allwood, either as quoted here or as in its own right.
yes, well, I was not proposing to go to the cases that are cited here because they are so thoroughly dealt with.
Yes, I see. So when we get to abuse, we will probably have to look at para 24. But for cause of action estoppel, we don't need anything more. I think.
No, I agreed, but it's convenient perhaps just to see it here, and one
Yes, no, that's...
probably won't have to look at it again.
All right, well, then you'd like us to read the whole of 24, would you?
Well, just picking up the beginning, that the principle in Henderson and Henderson has always been thought to directed against the abusive process involved in seeking to raise in subsequent litigation points which could and should have been raised before. Nothing controversial or new about that. And then he goes on to Lord Bingham in Johnson and Gore Wood, obviously a highly relevant authority, and that's set out in the last third of the page at 184.
Shall we just, although
Please.
it's very familiar, shall we just reread that to ourselves? Yes, and speaking for myself, I have just skim-read, quite familiar, paras 25 and 26.
Yes. Well, my lord, just in that citation from Lord Bingham, I would pick up the phrase at the top of page 185, not too dogmatic an approach to what should, in my opinion, be a broad merits-based judgment, takes account of the public and private interests involved, all facts of the case, and so on. So that's for the question of abuse.
Yes.
And Lord Millet is cited in the next paragraph. And if one looked just from below letter D, various defences, all designed to serve the same purpose, to bring finality to litigation, avoid the oppression of subjecting a defendant unnecessarily to successive actions. And in the last couple of lines, I'm inclined to regard it as primarily an ancillary and salutary principle necessary to protect the integrity of those defences and prevent them from being deliberately or inadvertently circumvented.
Yes.
And there's a jurisprudential distinction between res judicata and abuse, which his lordship deals with at letter G on page 185. They're distinct, although overlapping legal principles with a common underlying purpose of limiting abusive and duplicative litigation. And at the end of 26, at the top of 186, his lordship says, where the existence or non-existence of a cause of action has been decided in earlier proceedings to allow direct challenge to the outcome, even in changed circumstances, and with material not available before, offends the core policy against the relitigation of identical claims.
Yes.
So, Lords, I'm not sure I need, there's anything further, unless Mr. Reid wants something else read. So, turning back to our written submissions at page 32, we refer to the points not raised in previous proceedings. That's the Henderson point, which your lordships have now reminded your lordships of, and I don't think I need to take.
We can go straight to your next section, can't you? The one that's 31.
Yes.
About parties and privies.
Well, the only point I was going to pick out from our skeleton is on page 32 at our paragraph 30, we refer to the Mandich-Bozic British Association Counselling and Psychotherapy case. That's tab 29 in your lordship's bundle of authorities. It says nothing new, but we just draw attention to the fact that from paragraph 5 in the judgment of Mr. Justice Mostyn, from paragraph 5 through to the paragraph at the top of page 4, I'm not sure that I need the rest of his paragraph 5. There's a rather neat summary of the points made in Virgin and Zodiac.
Okay.
Lords, the next question we turn our attention to is parties or their privies. In fact, as your lordship sees in our paragraph 32, the judge applied the following test. Is Nexus seeking to challenge the outcome of Anderson? Could the points Nexus makes have been raised, and should they have been raised in Anderson? And thirdly, are the rectification proceedings between the same parties or their privies? And we've dealt with that question first because it appears to us to have influenced the judge's reasoning on the other 2 points. So at the foot of 33, we deal with whether the unions are privies or not, and we cite from Gleeson and Whipple, which is tab 10 of the authorities. And your lordships will see the nature of the claim in the first paragraph of the head note at page 510, which I won't read out. And Vice-Chancellor McGarry deals with this at page 515. at letter B, his lordship talks about a privity, who would be the real defendant. And Lord Reed agreed with a statement which applied the rules of res judicata to subsequent proceedings brought or defended by another on his account. And he's on X's account. The Vice-Chancellor says, this is difficult territory. I have to do the best I can in the absence of any clear statement of principle. First, I don't think...
Are you going to read all the sideline passages?
I was, my lord.
Yeah, shall we just read them to ourselves?
Of course.
Yes. Well, really, the key passage is the one on either side of G, isn't it?
It's at letter G, yes, indeed.
F to G and a...
Yes.
Yeah. Right.
And the example is quite interesting at H, that a decision binding on trustees also binding on beneficiaries and vice versa. Of course, our case is not an analogy for that, but it's in that sort of field. The next case, which we've cited, page 34 of our skeleton, is resolutions chemicals, and that's tab 27 in your lordship's bundle. At page 160, the sidelining starts. I wasn't going to read all that, but can I draw attention to the top of page 161, the first few lines of paragraph 24, which follows Gleeson and cites the passage your lordship have looked at in the judgment in Gleeson. In paragraph 26 on page 162.
Well, can we just note, I hadn't picked this up, that paragraph 25, Sir Robert's second principle was approved in Johnson and Gorwood. That must be the one starting clause secondary, which includes the passage that we noted particularly.
Yes.
Yes, okay, thank
you. And then 26, there's one particular case. C knows the proceedings between A and B that stands back and does nothing. Well, that's not our case, but it shows the breadth of the proposition. And then in paragraph 29 at the top of page 163, towards the end of that paragraph, some 6 lines down from the top of the page, the second concept concerns the identity of the parties. And then he quotes Lord Reed in Carl Zeiss Stiftung, and that is a quotation which we invite your lordships to read. So servants and agents may also fall within the concept of those who are privy, and that explained in paragraph 30, and the first sentence of 31 reads, it's not necessary for the purposes of this appeal to seek to define precisely what interest in the subject matter of the previous litigation is required. And then there's references to Gleeson again. And in 32, drawing this together, court which has the task of assessing whether there's privity of interest between a new party and a party to previous proceedings needs to examine A, the extent to which the new party had an interest in the subject matter of the previous action, B, the extent to which the new party can be said to be in reality the party to the original proceedings by reason of his relationship with that party, and C, against this background, to ask whether it's just that the new party should be bound by the outcome of the previous litigation. Of course, that's not quite the situation here. It's not whether a new party can be held to the judgment in Anderson, because the party we're asked to be held to it is the party that was in fact party to both, Nexus.
Yes. No, surely the way it fits here, am I not right, is the extent to which the unions,
yes,
the defendants to the new action, can be said to be in reality the party to the Anderson proceedings. That's
right. That's the question. I'm just pointing out that in this case, he's asking a slightly different question, where you've got where the defence, the estoppel is being raised by a new party. I'm sorry.
I suppose you would say that just as in Lord Reed's example, a defendant can't escape the estoppel by putting forward a servant or agent to commit a new wrong, so a claimant, here Nexus, can't avoid the estoppel by suing a party, namely the unions, who are not the real party in interest, i.e. the employees who were the parties to the previous action.
Your Lordship puts it far more elegantly than I could do. Now that's exactly the point I was endeavouring, but failing to make. My Lord, then finally from this judgment on page 164, reference to Lord Bingham, again, broad merits-based approach.
Well, this is a quote from Aldi, in fact, isn't it?
Yeah. And then in 34, necessary preliminary question in determining whether there's been abuse should be a sufficient degree.
So sorry, I misunderstood which way you're referring to. Do go on.
Yes. There should be a sufficient degree of identification between the respective defendants. Lord Justice Thomas rejected that, can't accept that. Lord Bingham made clear in his speech, the approach should be broad merits-based judgment and not formulaic. It's clear he was approving the passage as the correct approach and not a statement of rigid application. The fact that the defendants to the original action to this action are different is a powerful factor in the application of broad merits-based judgment. It doesn't operate as a bar to the application of the principle. So turning back to our written submission at 36, we might remind your Lordship that in the case we looked at a moment ago of Manditch-Bozic, whether the parties are the same is to be judged realistically and not literally, and we say the judge erred in his reasoning in particular by holding the unions are not in privity of interest with the Anderson claimants. I think what we should have said is not in privity of interest with the employees in the bargaining unit.
Not sure about that, because the estoppel must arise out of the fact of the previous proceedings to which only the Anderson claimants.
Yes. Well, either way, but certainly in relation to the Anderson claimants, they are closer still, but it extends to the breadth of the employees that they were on whose behalf they were negotiating. we would say. And we set out the various issues there about the negotiations that the unions carried out on behalf of the employees, and in 39 draw attention to the fact that the unions do the negotiation and reach the collective agreement, but its effect is when it becomes incorporated into the contracts of employment. And we say in paragraph 41 that the learned judge erred in failing to judge the matter realistically and not literally. And we set out various facts, relevant factors there. Claimants were members, and so on. The parties agreed statement of facts that the RMT funded and supported the Anderson claimants. The Anderson claimants called evidence from the RMT representatives. The judge considered it a material factor that the unions couldn't have been a party to the Anderson litigation, as your lordships have seen, but that's, we say, a matter of looking at it literally and not realistically. And the unions are defending this case on rectification only for the purpose of preserving the rights of the workforce, and in particular the Anderson claimants. Otherwise, they get no benefit from this at all, other than incidentally. And 41.4, we refer to that letter before action, which your lordships looked at before. So the next question is a challenge to the outcome of the Anderson litigation, but that might be a convenient moment.
It is a convenient moment. We'll sit again at 2 o'clock. Thank you.